Broadcasting from the business capital of the world, this is the Podcast Business News Network.
To make it official, this podcast is about many different things, but I'm going to say, what do these things have in common? Meat, checks, and lawyers. There is actually a connection to it, and we're going to talk about that today. She's got a lot of insight as an attorney in New York City. And what we are referring to is tariffs. We've talked about this before. We're back on it again. There have been some developments, and Carol Sigmond has her finger on the pulse of that. Welcome back. How are you doing today?
I'm doing well, Steve. How are you?
Good. So the meat reference is the price of meat. I bought this little tiny strip steak the other day. It was $16. I bought coffee. I expected the price to go down. I don't buy the foo-foo coffee, just a basic, there's not even a name on the coffee cup. This basic coffee was almost $4. All of it's because of the tariffs. The checks we refer to are the importers waiting for their check, supposed to be a refund. Where's that? And that doesn't necessarily mean the prices are coming down. That's just a reference point, but there have been a lot of developments since we started talking about this, right?
Yes, there have been, and there are more coming.
What's going on?
Well, I think we should start with the Supreme Court's decision in learning resources. We'll just talk about it. We all know the Supreme Court, 6 justices of the Supreme Court found that as a matter of statutory interpretation, the IEEP tariffs were illegal. So 6 justices said that. The 3 justices from what I would call the shifting middle, which is Justices Barrett and Gorsuch, as well as the Chief Judge Roberts. Chief Judge Roberts wrote the majority opinion on the statutory construction. Those 3 justices were joined by Justices Kagan, Sotomayor, and Jackson to make the majority of 6. So there were 6 votes that, as the plain language of the statute, did not support the president's imposition of IEEPA tariffs. Then we have additional opinions. 7 of the 9 justices actually wrote. The actual case opinion is like 190 pages, but it's fascinating because Justice Roberts has a whole section that's basically only joined in by Justices Barrett and Gorsuch on what is referred to as the major questions doctrine, which is a doctrine that's been evolving over the last 20 years that says when it's a big issue and we don't think Congress intended to give the administration this much power, we're going to look more carefully at what's going on. This major questions issue produced a great deal of writing. You had Justice Gorsuch engage both Justices Barrett and Kagan on the major questions doctrine. He is very, very strong on this doctrine, Justice Gorsuch. And he was pushing it hard. And part of what seems to have been going on with Justice Gorsuch, and this is just my opinion, I'm just observing as an outsider, he seems to be reading some very significantly serious legal work by Professor Amir from Chicago, who is writing on the fact that Congress has only limited effectiveness in its ability to moderate the president. Because the president has veto power over certain acts of Congress, and it takes a 2/3 majority to override them, Congress does not have as much power to limit the president. And this seems to be something that's bothering Justice Gorsuch. We know that from the oral argument in the IEP case when he made the remark that he did not think Congress intended for tariffs to be imposed because a Canadian province put up an ad the president didn't like. And so he seems to be troubled by this. Justice Barrett doesn't entirely agree with Justice Gorsuch on this issue. She is probably the most strict textualist in terms of original intent on the Constitution on the court. So she tends to be driven more by that perspective than the one that Justice Gorsuch is developing. So you have Justice Barrett on the one hand pushing back, and then you have Justice Kagan, who basically says this doctrine is of relatively recent origin, and I don't really like it. Now, what's interesting is that this, regardless of whether Justices Kagan, Jackson, and Sotomayor, all of whom signed Justice Kagan's concurring opinion on the major question doctrine, it may be that they're going to actually start to move toward Justice Gorsuch's position for somewhat the same reason. They may get there, they may reason it differently, but they're essentially going to get to the same position. That the courts are going to have to use the major question doctrine when it appears that congressional action may not be as effective as we would like. So you have that sort of evolving tension that was exposed very clearly on the court. Justice Jackson wrote separately, essentially criticizing the Chief Justice for not being more explicit about the intent of Congress in passing the IEPA. She cited extensively from the legislative history and criticized the Chief for not using more of the legislative history. Now, we know that that's something that Roberts has tried to push the court away from, legislative history. And we know that Justice Sotomayor and Justice Kagan and Justice Jackson do not agree with that. So we have that debate very clearly set forth for us, which we don't usually see. And then we saw Justice Kavanaugh. Both he and Justice Thomas wrote dissenting opinions. So Justices Alito, Kavanaugh, and Thomas did not join in the decision that the IEEP tariffs were barred by the statute. And we saw fairly clearly an argument in favor of the unitary executive coming out of both Justice Thomas and Justice Kagan, who do not want the courts questioning the president on this point. So you now have this kind of three-way situation on the court. You have Justices Sotomayor, Jackson, and Kagan, who want to go with congressional intent and do not want to deal with major questions and want a strong congressional intent opinion. You have Justices Roberts, Barrett, and Gorsuch with slightly different views of the major case doctrine, but all maintaining that that is part of the check on executive power. And then you have three justices pushing for more executive power. And what I detected a little bit of in the decision is a pulling back from strong executive power by Justices Barrett and Gorsuch. And how this plays out over time, we will wait and see. But we have this, it's a very clearly delineated set of opinions, and there are some clear fracture lines in the court. One of the things that's interesting is that it's now clear why Justice Barrett has from time to time aligned herself with the other three ladies on the court. When they are all reading the statute and they are being textualists, they tend to read it the same way. So that's another sort of inside baseball for everyone to look at. I mean, the decision's public. You can go to the Supreme Court's website and pull down the Learning Resources decision. All 190 pages, makes very interesting reading. And I will confess to you, it took me an entire weekend to get through it.
Well, Well, I want to ask you at this juncture,
Yeah.
why is there a variance of interpretation here?
Well, there are different ways to look at the Constitution. Justice Scalia, may he rest in peace, and Justice Barrett are very literal. They want to read what's in the document. Some justices want to stay with what's called original intent or the text of the Constitution. There's been a whole other class of justices who have wanted to say, look, it's not just what the circumstances were in 1786 or 1790. We need to look at where we are today and how to make this document a living document. And so there is a debate on how to make the document a living document and what does it mean. And all of the points of view are legitimate. Let's be very clear. Everyone has a legitimate point of view here. They're just different. What's interesting is that this case is showing us that even though you have Justice Barrett and Justice Gorsuch who look at this, the Supreme Court look at the Constitution one way, and Justices Kagan, Jackson, and Sotomayor looking at it and reading it in with a different set of interpretive ideas, what you have is a merging of their conclusions. And that's happened many, many times on the Supreme Court. So I think we should just watch that just out of interest to see where the court is. Court's lost a lot of respect over the last few years, especially since the reversal of the Roe decision. But there may be a way to reinterpret this so that it's maybe less distressful and maybe more consistent with where the public thinks the court ought to be.
Could this whole situation have happened 200 years ago? Could we be in the same situation?
Sure. And we probably were. I mean, we've had lots of 5-4 decisions over the years in lots of issues. I mean, I can pick some really famous ones that are not very pleasant where this happened, like the First and Second National Bank cases and Dred Scott and how that played out, and Plessy versus Ferguson, which ends up being reversed in Brown versus Board. So there's been lots of evolution in philosophical views, but we are where we are right now. We have these 9 people, and we have a very good set of insights into how they think based on these 7 opinions. The only people who didn't write were Justices Alito and Sotomayor. Justice Alito signed the dissents by Justices Kavanaugh and Thomas. Justice Sotomayor signed one part of Justice Roberts' decision, the part that got 6 votes, and she then signed the decisions from the concurrences by Kagan and Jackson. So we know what 7 people thought about this, which is really very interesting and very helpful. But they touched off a new issue. And let's take a couple of minutes to talk about this, because this is actually big news. So, and there are 2 pieces to it. There's 100, by some estimates, somewhere between 160 and 180 billion dollars that was collected in these tariffs, in the reciprocal tariffs. That money has to go back. It has to be refunded by the government. There are now approximately 2,000 cases pending at the Court of International Trade, and the chief judge of the Court of International Trade has assigned a single judge to monitor this entire process. So there's only one judge who's hearing all of the IEEPA refund cases. And remember, the Court of International Trade is a national trial court, and so it has national jurisdiction, so all the cases are coming there. And that incidentally was affirmed by the Supreme Court. There was actually no argument about the fact that the CIT had exclusive jurisdiction of these cases. So now we have Judge Eaton, who has said to the Customs and Border Patrol, you will stop collecting IEEPA tariffs. You may not do this anymore. Anything that was in process, he ordered liquidated, meaning essentially canceled. Then he said to them, how are you planning to refund this money? And he's holding weekly conferences, or not strictly weekly, but periodic conferences with the government and the lead plaintiff counsel. Artemis Filtration is the lead plaintiff in the refund cases. And so the lawyers are coming in periodically to see the judge to discuss where the Customs and Border Patrol is in the setting up essentially a computer system within their system to refund money. They have to compute it, they have to give it back. There's a whole argument about interest. I think it will probably be returned without interest, but that's that. But the money is going back to the importers who paid it. It's not going back to the consumers. And you have both efforts in Congress, and you have Governor Hochul, for one, you have the attorney generals of both New York and Oregon calling for the money to go back to consumers. It's an interesting problem. Under Title 19 of the Code of the Federal Law, the refunds belong, they're the property of the importers. So if you were to say, we're not going to give the money to the importers, we're going to give it to consumers in the form of a tax refund or some other distribution, now you've taken the property of the importers without compensation in violation of the Fifth Amendment of the Constitution, so you've set up another constitutional problem. I don't know how they're going to think that one through, but I don't think Congress can legislate, and I think the money has to go back to the importers. Now, interesting. Now, gets a little tricky from there. The importers may not be able to keep all of this windfall. Some of them may have done this as surcharges, which their customers can then claim as rebates or discounts. And there may have contracts or purchase orders that require the importer to pass along the rebates or discounts. So that's one possibility. Some customers of importers may have actually included contract provisions that say, you're going to give us duty, it's called duty drawback. You're going to give us back any duties you get back. There's going to be an argument, I'm certain, on unjust enrichment, that this money clearly doesn't belong to the importers. It should go back to the people that purchase from the importers. That isn't even the ultimate customer. That'll be the retailer. And then the retailers will have to figure out what to do. And there could be arguments of unfair trade practices. And that's, I think, not a very strong argument, because I don't think it's possible to accuse someone of fraud if all they did was collect a tariff that the government told them to collect. So I'm not sold on that. But it's going to be lots of litigation. The big winners in this are going to be the lawyers, the importers and the lawyers.
So a couple of quick questions here.
Yes.
What are your feelings about one judge hearing 2,000 cases?
That actually makes sense to me.
Really?
Yes. And the reason is that there's no legal issue here. The Supreme Court has decided the case.
Okay.
They affirmed, remember, because we've been following this case for a year now. So we had the original CIT decision that said the IEP tariffs were illegal. We had the affirmance by 7 of the 11 judges on the Federal Circuit. Now we have 6 of the 9 justices on the Supreme Court. So technically, the decision of the Supreme Court was to affirm the decision of the Federal Circuit, which in turn was affirming the decision of the CIT. So the case goes back to the CIT to effect a remedy. Essentially, it's just compute the amount of money that's due each of these importers and give it to them. And that's an arithmetic problem. That's not what I would call a legal problem.
But I guess that one judge needs to distinguish the validity of the lawsuit. And I guess that's based on evidence to prove that the importer paid.
Yes, Oh, that's yes. Each importer that has filed an action has to have their paperwork. They've
Right.
all probably filed paperwork with the Customs and Border Patrol to get their money back. They all have to have proof and receipts and stamps. That's not the issue.
Sure.
But that's not a big judicial issue. I mean, he
I
can
got you.
decide on papers. What the chief judge of the CIT wants is consistency in the refund process. She doesn't want one judge ordering the Customs and Border Patrol to do the refunds, say, by plan A, and she doesn't want a different judge coming up with plan B and a third judge coming up with plan C. She wants one plan,
Yep.
one place, and that's really to benefit the government. So they don't have too many cooks in the stew. They can deal with one judge who can give them guidance and direction on the schedule and the refund process. To me, it's a very sensible decision. You know, a good process.
It just seems like it's going to take a while for that money to be refunded, but it is what it is. But at least there is consistency and accountability for that. So let's get back. Let's look at, with the time we have left here, the regular people, that cup of coffee. What are the chances?
Prices are sticky, my friend.
Yeah.
Price isn't coming down, I don't think. And everything has been complicated because as soon as the IEEPA tariffs were found to be illegal, the administration immediately invoked Section 122 of the 1974 Trade Act and put new tariffs on. They're not as high as the old tariffs, but they are just as broad-based. They are also being challenged. Those tariffs went on at the end of February, and on March 5th, 24 states sued in the CIT, maintaining that the new tariffs, the tariffs under this 1974 Trade Act, Section 122, are also illegal. We'll take a couple of minutes and just kind of think about that, because that's also a very interesting issue. In the early 70s, 1973, when the U.S. basically went off the gold standard, there was a bit of a dumping of the dollar, and there was a balance of trade imbalance and almost emergency. President Nixon, with not a lot of authority, he had TWIA, but not a lot of authority, went in and essentially put on tariffs and took other steps to stabilize the currency. Congress at the time looked at the situation the president had confronted and essentially codified what the president had done in the 74 Trade Act. So they gave the president the authority to deal with some kind of balance of payments crisis. But we don't have a balance of payments crisis right now. We have a relatively even situation and nobody's really dumping the dollar. It is not at all clear to me, and again, we have lawyers on the left and lawyers on the right. We've got the same situation we had with the IEEPA tariffs. The lawyers that are looking at the trade lawyers, regardless of whether they're from the Federalist Society side or the non-Federalist Society side, are all looking at this saying, where's the balance of trade crisis? And there isn't one.
I just looked up. We're out of time. We could keep going here. There's so many different pieces. But I appreciate you making it very clear of what's going on, because you really don't hear about this to this degree anymore. And it's fascinating in modern times where we're at here. It's just mind-boggling that all this billions were paid now has to be refunded. Consumer is not going to benefit, most likely. So who actually benefited from this in the end?
The importers.
Thank you. If anybody's, and I don't take any political sides here. This is just the facts.
It is what it is. The lawyers, don't forget the lawyers.
Oh, no. Would love feedback, input, questions, anything. For Carol, instantfeedbacksteve@gmail.com, the best way to reach us. Thanks for being here again today and breaking this all down. Mind-blowing. It was a year ago. It still is.
Well, I was right. The IEP tariffs did not survive.
You said
And
that.
now I'm going to tell you I don't think that Section 122 tariffs will survive either.
Mm. Can you tell me that the price of meat and other things are going down?
No, I'm not telling you that.
No, I know
I
that.
will say this. I hope that the customers of the importers wise up and arrange to get these refunds returned to them so that they can lower prices to their customers.
Gotcha. But even if
I
they get
hope
that money,
happens.
who's to say that they're going to pass that on to the consumer? You know, be
Nobody.
nice, goodwill,
Be
but
nice, but don't count on it.
Yep. All right, Carol.
Pricing is sticky, my friend.
Thank you for being here today. Really appreciate it.
Thank you.
Broadcasting from the business capital of the world, this is the Podcast Business News Network.